Legitimacy of international law and the exercise of administrative function. The example of the International Seabed Authority, the International Maritime Organization or IMO, and International Fisheries Organization. It is possible to speak of international administration only if an international entity is truly exercising function equivalent to state. While such cases are rare, as Joseph Whaler emphasized in a different context, they do exist. One such case is the International Seabed Authority, which exercises legislative as well as executive function concerning the international seabed area and its resources. Furthermore, the legal regime on the international seabed comprises a fully elaborated system for the settlement of disputes available to public and private actors involved in the exploration and exploitation of mineral resources in the area. The function assigned to IMO and some fisheries organizations haven't quite reached this level. Nevertheless, one can observe that this organization do prescribe binding rules at least de facto. However, they lack the jurisdiction to enforce such rules directly. In that respect, they are relying on the enforcement of state to enforce such rules acting under different capacities, such as flag state or port state. One may consider this legal regime as belonging to a multi-level system where the perspective and executive function are being vested in different entities. The contribution will examine why legitimacy is crucial for entities engaged in the exercise of exercising function, which may be qualified as international administrative law, and whether the International Seabed, the IMO, and the North Atlantic Fisheries Organization, as the one are being particularly developed in this respect, possess such legitimacy. Legitimacy in international law. In recent years, the question concerning the legitimacy of international law has been discussed quite intensively. Different authors mean different things by the term legitimacy, although it mostly means to refer to the justification of authority, this notion being understood as the equivalent of having the power to take binding decisions, be they prospective or executive. Such decision may be general or specific in nature, a distinction which may be of relevance to their legitimacy. Scholars have suggested a variety of approaches concerning the element which may induce legitimacy for a particular authority. Theoretically, they may be source, procedure, result-oriented, or a combination thereof. First, authority can be legitimated by its origin of power. An example is state consent to international treaties. International law proceeds from the assumption that states have the authority to negotiate and to adhere to international agreement and the duty to comply with such agreement. States which become parties to such agreement through this accept obligation vis-a-vis the other partners to the agreement de facto towards a larger community. Second, authority can also be legitimate because it involves procedures considered to be adequate or fair, rules concerning the composition or establishment of an institution, and its rules concerning the taking of decision are to be seen from this point of view, procedural legitimacy. procedure, or rather adhering to a pre-agreed procedure which is considered to be adequate and fair, thus has a legitimizing effect in international law as it has in national law. Finally, authority can be legitimated or delegitimized by the outcome of its decision, substantive legitimacy. This is a crucial issue and one which deserves careful consideration. If a particular body such as the Security Council or an international court or tribunal, although being established according to the applicable rules and taking decision according to the established procedure, but doesn't achieve result that the community to which this decision are addressed is considering this decision to be adequate or fair, this may in the long run lead to an erosion of its legitimacy. In other words, an international organization legitimacy is based on its procedural as well as its substantive legitimacy. The fate of the UN Human Rights Commission provides a useful example. The dissatisfaction of the international community with the performance of the UN Human Rights Commission has led to the establishment of the Human Rights Council, whose composition differs from the former Human Rights Commission. In this regard, it is of particular relevance that a member to the Human Rights Council may be expelled if it is violating internationally protected human rights significantly and systematically. However, having said that, it cannot and doesn't mean that the legitimacy of an international body should be judged morally as to whether its decisions are considered as being satisfactory by a state, a group of states, or a community to which they are addressed. A further element of substantive legitimacy may be efficiency. However, this element should not be overrated. Frequently, the rules on decision-making of organs provide for the protection of particular state or group of states as provided for example, by Article 27 UN Charter. The inability to overcome this threshold is often, but wrongly been considered as inefficiency. A discussion on legitimacy of international law should proceed from international treaties, the primary source of international law. International treaty law is being developed on a consensual basis. State representatives negotiate international rules which subsequently are adopted by the national institution in a procedure designed by national law. Depending on the national system, this may include parliamentarian approval. Thus, it is for the national law to ensure that there is a legitimacy chain justifying the implementation of international obligation based on a treaty through national institution. As a matter of principle, one may say that as far as consent-based international law is concerned, the legitimacy of the obligation deriving from the original consent is also to be established on the national level through nationally established mechanism. In practical terms, consent of state can have two different meanings, namely a specific one referring to a particular obligation and a more general one referring to the establishment of a regime or a system of governance combining prescriptive and executive function, which after having been set up by consent develop a legal life of its own. These two options are not as distinct as one may assume. Rather, in practice, they tend to blur into one another. The consent of a state concerned will undoubtedly suffice if the obligation is a specific one and can be implemented by an isolated act or omission. The same is true even if the obligation is of a continuing nature and requires continuous activities or emission. However, there remains the risk that the legitimizing effect of the original consent may be eroded over time. This would be particularly true if, due to changing circumstances, the burden of implementing this obligation significantly increased. Thank you.